Of 2010, you receive evidence that two members of the KKK in Mobile, Alabama, appear from the evidence you received to have been intimidating potential voters. What would be the reaction of your office?
We will receive the allegation. We will conduct an investigation. We will apply the facts to the law and reach a conclusion.
If you have people who are long-term employees of the Department of Justice and the Attorney General's office who indicate that this is clearly abuse and you can take action against the individuals and getting a judgment, you would be able to pursue discovery and find out whether it was a widespread plot or just locally. Wouldn't you go ahead and pursue that?
We will include all of the people involved in the decision-making process.
And why would you not do that with the Black Panthers when you got the video of what occurred in Philadelphia instead of ordering the dismissal of what was clearly going to be a judgment and could have allowed for discovery to be forthcoming and sought out whether or not there was a widespread conspiracy or whether this intimidation was limited to Philadelphia?
Sir, two career attorneys with over 60 years of experience reviewed the decisions that were made on January 7th, 2009 by the previous administration, reached a conclusion that the charges against one of the defendants were warranted, sought and obtained the maximum penalty, and concluded that based on the facts and the application of the facts to the law, that the charges were not sustainable against the remaining defendants. And
were you aware that they did not even file an answer? How is that not sustainable? They didn't file an answer. They were going to get a judgment. And what were the names of those two career officers who could not figure out that the judgment that the judge had asked for and to be prepared and submitted, that it certainly appeared he would sign? There was no response. What are the names of those two individual brilliant legal jurists who said they couldn't get a judgment?
The law of the Third Circuit requires that before a default judgment
but what were the names of the two career individuals? My question is,
Loretta King and Steve Rosenbaum, sir.
And Loretta King and who else?
And they came up and made themselves available.
Loretta King and who else?
Steve Rosenbaum, who was the acting Deputy Assistant Attorney General for Civil Rights.
Had those two been handling the case?
They were the two people in the front office, the two career people who were overseeing that case.
They were overseeing, but they were not handling that case, were they?
They were reviewing the case, and they reviewed the entire record and made the judgment regarding the application.
Is it your opinion, with your distinguished career and your great education and experience, that when you have a judgment that the judge has asked for and the respondents have not responded, that you could not get a judgment in that case? Is that your opinion?
So it's my view that we have to follow the laws of the circuit, and in the Third Circuit, the law is that if you are going to seek a default judgment, you need to be able to represent to the court. There's a rule, Rule 11, that requires you to be able to represent to the court that the charges you are putting forth are charges that are supported by the facts and the evidence.
Did you review the video of those guys out in front of that polling place?
Whenever a case is brought to anyone's attention, you review
did you review the video of the individuals out in front of that polling place?
It's important, Congressman, to review the totality of the circumstances.
And I'm asking to get to the totality you reviewed, if anything. Did you review the video of those guys out in front of the polling place, and one of them with a billy club?
Sir, I am not the person who reviewed the case because I was not working.
So your answer to my question is no, you did not review that video. Is that correct?
I have incredible confidence in the judgment of the two career people who made
the answer to my question is no, you never saw the video. Isn't that right?
I've actually seen the video, sir.
Okay, there we go. Thank you. That was the question.
Yes.
That helps me know whether you reviewed the totality of the circumstances yourself.
No, I haven't reviewed the totality of the circumstances myself, and I look forward to the report of the Office of Professional Responsibility, which was asked for by this committee. And
Mr. Perez, as smart as you are, you know how important around the world that it is to avoid voter fraud and voter intimidation. And so in Iraq, they dipped their finger under threat of death in purple permanent ink, knowing that they would be subjected to death. And here, we can't even get the justice. But I don't care which administration.
Time has expired, but I'll let the witness answer the question.
Yes. But you understand.
I'm not sure. The time has expired. The witness may answer the question.
Consent, the gentleman be recognized for an additional minute.
I'm not sure there was a question.
We cannot do that. We have 6 minutes left on the vote on the floor. Gentlemen, the witness may answer.
I wasn't sure that there was a question.
The question started with, were you aware, or you are aware, of how important?
So I certainly share your desire and interest in ensuring that elections are carried out in a manner that is free of intimidation. And I also share your desire to ensure that investigations are fully and fairly carried out. I look forward to the results of the OPR investigation. We have cooperated fully. We'll continue to do so and await their results.
And please do so with the KKK or anybody else that you find there's evidence of voter intimidation.
Yes, sir.
Thank you. The gentleman from, without objection, the gentleman from Virginia is recognized for briefly to ask a question which the witness will give an answer to later.
Very briefly. Okay.
Thank you. If you could get back to me on the answer. Under parents involved in community schools versus Seattle and the Michigan affirmative action cases, the court has made it clear that voluntary desegregation programs and affirmative action programs are legal, but only if they're done correctly. My question to you is if you could provide us the guidance you are providing to local school systems and universities and others about how to fashion desegregation programs and affirmative action programs so that they can pass constitutional muster. And if you could get back to me on that, I'd appreciate it.
I look forward to discussing that issue with you.
So that I thank the witness, I thank the members, so that we don't miss the votes on the floor. There are now 4 votes on the floor. There's 4 minutes and 45 seconds left on the first vote. So we will recess the hearing until the conclusion of those votes. I ask the members and the witnesses to be back as soon as the votes conclude, as rapidly as possible thereafter. Mr. Perez, you're excused.